Reservation in India is a form of an affirmative action whereby a percentage of seats are reserved in public sector, civil services, government departments, and in all public and private educational institutions for the socially and educationally backward communities, for the scheduled caste, and for the scheduled tribes. It is prescribed under Article 15 Clause 3, 15 Clause 4, and 16 Clause 4 of the Constitution of India. The Supreme Court, in the landmark judgment of State of Kerala versus N.M. Thomas, has held that reservation is not an exception to the right of equality. Rather, it is a facet of the right to equality, which fosters and furthers the idea of equality of opportunity to the underprivileged and deprived class of citizen. In Indira Sani and others versus the Union of India, a landmark judgment of the Supreme Court, the Supreme Court held that the total number of reserved seats, places, or positions cannot exceed 50% of what is available. The Supreme Court held that this rule of 50% applies only to reservation in favor of backward classes. The Supreme Court also held that there are two types of reservation. One is vertical reservation, which is also known as social reservation, which is provided for the scheduled caste, scheduled tribes, and other backward classes, which is prescribed under Article 16, Clause 4 of the Constitution of India. The second type of reservation is known as horizontal reservation, which is also known as special reservation, which prescribes reservation for women, physically disabled candidates, ex-servicemen, relatives of freedom fighters, etc., which is provided under Clause 1 of Article 16 and also under Article 15, Subclause 3 of the Constitution. The Supreme Court in these landmark judgments also held that the candidates belonging to SC, ST, and backward classes can compete for non-reserved posts in open category, and if they are appointed to the non-reserved posts on their own merit, then their numbers will not be counted against the quota reserved for respective backward classes. This principle is applicable only to vertical reservation and is not applicable to horizontal reservation, which is provided for women, physically disabled, ex-servicemen, etc. Horizontal reservation cuts across the vertical reservation and therefore it is known as interlocking reservations. Now I will explain how this horizontal reservation is to be calculated and what is the procedure and the method of formulating and implementing this horizontal reservation. The High Court of Gujarat, in the judgment of Tamanna Ben Ashokbhai Desai versus Sheetal Amrutlal Nishar, has explained this procedure very succinctly, and the Supreme Court in the judgment of Saurav Yadav and others versus State of UP has upheld this judgment of the Gujarat High Court and has approved the procedure laid down. And this procedure prescribed by the High Court will have to be applied and followed by the government in all its recruitment process. So let us understand the method of implementing horizontal reservation in public employment by an example. For example, if the posts of 100 police inspectors are vacant and to be filled by public employment, then as per the reservation, 51 seats will be for open category, 12 seats for scheduled caste, 17 seats for scheduled tribe, and 20 seats for SEBC candidates would be reserved. Now, out of this, 33% reservation for women, which is a horizontal reservation, which will cut across all vertical reservation, will have to be like this. Total seats would be 33, out of which 17 seats for open category, 4 seats for scheduled caste, 6 seats for scheduled tribe, and 7 seats for SEBC. So the proper and correct method of implementing horizontal reservation would be to follow the steps provided by the Gujarat High Court in its judgment. The steps provide that the first step would be to draw up a list of at least 150 candidates so that there is no shortfall of appointees when some candidates don't join after offer. Qualified to be selected in the order of merit. This list will contain the candidates belonging to all the aforesaid categories. The next step would be from the aforesaid list to draw up a list of first 51 candidates to fill up the open category quota of 51 seats on the basis of merit. This list of 51 candidates may include the candidates belonging to SC, ST and SEBC along with non-reserved candidates. The next step would be for horizontal reservation in open category quota would be that in the list of open category, if there are 17 women, women's quota of 33% is fulfilled. Nothing more is to be done. But if there is a shortfall of women, say for example only 10 women are available in the list of open category, then 7 more women have to be added. The way to do this is to first delete the last 7 male candidates of the step 2 list. Thereafter, to go down the step 1 list after item number 51 and pick the first 7 women. Category does not matter, according to merit. As soon as 7 such women from step 1 list are found, they are to be brought up and added to the step 2 list of open category to make up for the shortfall of 7 women. Now the 33% quota for open category women is fulfilled and the list of open category is to be locked and step 2 list of open category becomes final. The next step would be to move over to the scheduled caste reserved seats. So from the step 1 list, after item number 51, draw up a list of 12 scheduled caste candidates, male or female. These 12 would also include all male scheduled caste candidates who got deleted from the step 2 list to make up for the shortfall of women in open category. The next step would be to do a check for horizontal reservation in step 4 list of scheduled caste. If there are 4 scheduled caste women, the quota of 33% is complete and nothing more is to be done. But if there is a shortfall of scheduled caste women, say for example only 2 women are available, 2 more women have to be added. The way to do this is to first delete the last 2 male scheduled caste candidates of the step 4 list and then to go down the step 1 list after item number 51 and pick the first 2 scheduled caste women. As soon as 2 such scheduled caste women in step 1 list are found, they are to be brought up and added to the step 4 list of scheduled caste to make up for the shortfall of scheduled caste women. Now, the 33% quota of scheduled caste women is fulfilled. The list of scheduled caste is to be locked. So the scheduled caste list becomes final. If 2 scheduled caste women cannot be found till the last number in the step 1 list, these 2 vacancies are to be filled up by scheduled caste men. If in case the scheduled caste men are also wanting or not available, the social reservation quota of scheduled caste is to be carried forward to the next recruitment unless there is a rule which permits conversion of scheduled caste quota to open category. The same steps have to be repeated for preparing the list for scheduled tribe and for the SEBC candidates. This is how the entire process and method for implementing the horizontal reservation has to be applied. And if it is not done according to the steps indicated above, it would result into the negation of the right to equality and also the law propounded for vertical and horizontal reservation by the Supreme Court and would prejudice several candidates, and the said list would be susceptible to challenge before the courts of law. So therefore, according to the Supreme Court judgment, this process and method has to be followed in order to comply with the horizontal and vertical reservations. I hope this clarifies this issue on vertical and horizontal reservation.